Well, it's that time of week once again. Our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay, with us each and every Thursday just after 8:30 to offer her legal expertise by providing some general advice on the latest of hot topics. And we've been talking about some of the hot topics we've got coming up this week and in coming weeks. Looking forward to all of those. Of course, she has experience spanning more than 25 years in the area of property and commercial law. She also prepares wills as part of estate planning and litigation, and she's with us right now. Hello, Despina.
Good morning, Wayne. Good morning, Brooke.
Good morning, Despina. So this morning, it's a very interesting segment once again, and it's in regards to the binding death benefit and looking a bit more closely there at nominations. So can you explain what exactly this is and why it's so important?
Yes, I can. So I wanted to raise it because I think that the superannuation death benefit payment, I think, is not given enough consideration. And when people go ahead and put these in place as part of their estate plan, perhaps sometimes they don't actually think about the potential outcomes and consequences of doing this as part of their estate plan and how it may flow on to their families. They may think that they have, but it really does take careful consideration when you go and provide or put in place a superannuation death benefit. And then, of course, added on to that sometimes is what you just referred to, which is this binding death benefit nomination that you can also put in place. So to explain very simply, with a superannuation death benefit, you can choose to put in a binding death benefit nomination or not. It is up to the person in question, and I'm not here today to obviously advise whether people should or should not, because that's financial advice and they should go see someone about that, particularly a financial planner. But what we can talk about is the different consequences for your estate plan if you do put a binding death benefit nomination in place or if you don't.
Mm-hmm.
So putting it very simply, if you have a superannuation death benefit, now in that policy you will nominate someone to receive that death benefit, so monies, after you pass away. And typically people will nominate beneficiaries to receive it directly, so either a spouse or a child, so someone who's eligible, or a financial dependent, or they will actually nominate their estate to actually take that benefit. So first of all, there are different consequences, which I say to people all the time when they see me about wills, so they understand, okay, if you have a superannuation death benefit and you've named someone as a beneficiary, generally, without putting a binding death benefit nomination in place, the trustee of that policy has a discretion to pay those proceeds to the named beneficiaries in the first instance. So they don't have to, but they generally follow the wishes and directions, but they don't have to. So that's the first thing I want to say. The second thing I want to say is that if the monies are paid directly to a named beneficiary, so a spouse or a child,
Mm-hmm.
then those monies don't come into your estate. A lot of people don't understand that. So they're thinking, okay, I've got this superannuation death policy and these benefits. The monies are going to be put into my estate, and it's really for the benefit of my wife or husband, for example, but it's going into the estate and it'll be used to pay off debts, for
Mm-hmm.
example, like a mortgage debt or other monies that need to be paid off. Now, if you've named a beneficiary and the trustee goes ahead and follows those directions, then those monies actually don't come into the estate, so they can't be used to pay off your mortgage or pay off the debt or anything like that, because it's paid directly to the named beneficiary. So there is a difference there, which a lot of people don't understand.
And one thing I think that we talked about before we came on air was how easy it is to get this wrong. You need to be fairly specific in order to have your wishes carried out after you die.
Yeah.
Yes, so we want to get to that, and that's the binding death benefit nomination part. And we'll do that in a minute, because that's quite important. So if you go down that path, you've got to make sure it's done right and it's enforceable. Otherwise, it won't be enforceable and your wishes won't be carried out. But the other thing to mention about putting in place or having named beneficiaries where they receive this superannuation death benefit, it might be to your advantage to do that in blended families, for example, or where you think your will be challenged. Because as you can imagine, if the monies are paid directly to a beneficiary over here on that side, for example, the monies actually don't come into your estate and they don't form part of any claim that is made by potential people that have a claim that can challenge your will. So you can see there's some advantages there, and you could also put it in place to protect some vulnerable beneficiaries that you might have in your family. So there are advantages in doing that. Over on the other side, we've got something, as I called it before, the binding death benefit nomination. So if you put that in place, you actually have your trustee who is bound to follow at law what you put on your policy and who is to receive your death benefit. And that's why it's called binding death benefit nomination. But there are a couple of things with this, or a few things. You've got to make sure it's valid. So that's why you need to always see a financial planner, make sure it's been carried out correctly, because if it's not and it's found to be invalid, then it's like you never put it in place in the first place and your wishes won't be carried out. And sometimes it can have devastating consequences. So, for example, for it to be enforceable, basic things like it's got to be properly executed as per the rules of your trust fund. It's got to be in writing. You've actually got to nominate a percentage. Believe it or not, people put named beneficiaries and they go, oh, well, I forgot to actually say that my spouse gets 50% and my child gets the other 50%. So, well, that's not going to be enforceable because you haven't put a percentage, right? It's got to be signed and dated by you, and it's got to be witnessed at the same time by two independent witnesses, and those witnesses can't be a named beneficiary.
Someone else. Yeah.
So you can't just do it at home with your family who might be named on the policy, which sometimes people have done in the past, and that's wrong. And you've also, whoever you've nominated, have also got to be eligible at law to receive it. So spouse, children, people who are financially dependent on you. But also, if you nominate your estate, which is nothing wrong with doing that, if you put in a binding death benefit nomination, you say, okay, I want the money to be paid to my estate. There's actually proper terminology you've got to use. And you've got to use the words generally. You've got to use the words legal personal representative. And if you don't, that could also be seen to be invalid.
Wow.
I know. And there's a big case in Queensland back in 2015 called Munro in the Supreme Court. And that was just to give you an example so people can understand the true implications if you get it wrong. So in that case, the deceased put in a binding death benefit nomination and it was actually declared invalid after he passed away. And the reason why it was declared invalid is because instead of writing legal personal representative, which was required by the rules of that particular policy, the trust fund, he actually put in the words trustee of deceased estate. And because he used the wrong words, don't know how that came about, then it actually was classed as invalid. And then the consequence, which is the interesting part, is this. The consequence of it being declared invalid was that because it was no longer binding, right? So because it was no longer valid and the proceeds could not then be paid to his estate, right? The legal personal representative, that's what he really intended, but he used the wrong wording. And what happened is then the trustee of that fund, which was his wife, which was his second wife, from his second marriage, of course, she actually exercised her discretion being the trustee of that fund, and she paid all the proceeds to herself. Now, his children of his first marriage missed out, and because had it been paid to his estate, they would have benefited under the will. So you can see the severe consequences sometimes.
Completely change your plans, 100%.
Yeah, which is obviously not what he wants. Just briefly, Despina, is this one of those things that you just set and forget?
No, good question. So generally, you have to check the rules of your trust fund, which is why when you set up a binding death benefit nomination, you talk to your financial planner, check out the rules in place, because generally there is a 3-year lapsing rule. So it's in place for 3 years generally, and it'll expire, it'll lapse. So you always have to renew. Now, there is an exception to that if you do it under a self-managed super fund. But again, you have to check the rules, be aware. And if you do have one that expires every 3 years, yes, you've got to renew it, right? But what happens if you lose capacity? So what happens if you lose capacity, you're still alive, how can you renew it? Because you don't have capacity to do it, because you've lost your mental capacity. So what happens in that case?
Yeah.
And that's why I mentioned to people, talking about your estate planning, make sure you have an enduring power of attorney in place, and make sure that document gives your attorney power
to be
renew
able
it.
to renew it.
Really
Yeah.
important. Yeah.
So handy. Thank you so much, Despina. So coming up next, Talking Law does continue. The sleeping giant awakens and wants your money. Stay tuned to find out who that is on Talking Law. You're on Radio 97.